Timor-Leste oil gas, new maritime treaty with Australia. On 6 March 2017 in New York, delegation of both countries signed before the United Nations Secretary-General and Portugal's former Prime Minister Antonio Guterres the treaty between the Democratic Republic of Timor-Leste and Australia establishing their maritime boundaries in the Timor Sea. New maritime boundaries. The new maritime boundaries between the two countries represent, after almost 50 years, Australians' renounce to the geological criterion for the definition of the extension of continental shelf based on the natural prolongation of the landmass and follows the principle of delimitation by mutual agreement and in accordance with equitable principles. Particularly, the delimitation is made by the application of the median line, roughly the southern boundary of the current Joint Petroleum Development Area (GPDA). The dispute, now handled, commenced in 1972 with the rejection by Portugal, then the colonial power over Timor-Leste, of Australian claim following the agreement reached between the latter and Indonesia in the Seabed Boundary Treaty, thus originating with the establishment of the maritime border between Indonesia and Australia close to the Timor through a gap, the Timor Gap, between points A16 and A17, where the overseas Portuguese territory of Timor and afterward the territory of Timor-Leste stand. The new maritime boundary is aligned with Timor-Leste's long-time public claim and a welcome outcome of the compulsory conciliation process initiated by the small half-island state against Australia in April 2016 under Section 2 of Annex V of the United Nations Convention on the Law of the Sea. Petroleum resources. Greater Sunrise. The treaty establishes in its Article 7 a special regime for the Greater Sunrise oil field, instituting a special regime area in which the parties shall jointly exercise their right as coastal states pursuant to Article 77 of the United Nations Convention on the Law of the Sea. This special regime will cease to be enforced following the commercial depletion of the Greater Sunrise field. The following is the depiction of the outline of the special regime area and the Greater Sunrise field used in the treaty. Article 2 of Annex B lays down an upstream revenue share system, revenue derived directly from the upstream exploitation of petroleum produced in the Greater Sunrise field, as follows. In the ratio of 70% to Timor-Leste and 30% to Australia. In the event that the Greater Sunrise field are developed by means of a pipeline to Timor-Leste, or in the ratio of 80% to Timor-Leste and 20% to Australia in the event that the Greater Sunrise field are developed by means of a pipeline to Australia. To be noted that the development of the Greater Sunrise field by means of a pipeline to Timor-Leste is a long-time aspiration of the Timorese authorities and deemed very important for the viability of the ambitious TASI main project, outlined in the Timor-Leste Strategic Development Plan 2011 till 2030, and in which billions of dollars were already spent. Despite the Timorese government's previous position that it will only approve the field development of Greater Sunrise if its gas is piped to Timor-Leste onshore on an LNG plant is developed in PICO 4-5. The treaty subject Article 9 of Annex B, the production of petroleum from the Greater Sunrise field to a development plan in accordance with the development concept approved by the government in the two countries, to be submitted by the contractor to both the designated authority and the governance board, and to be approved by the latter. However, the condensed comparative analysis of alternative development concept attached to the treaty conclude that for the Timor Gaps concept to achieve an acceptable rate of return on the downstream project without exceeding the tolling fee that the upstream concept could actually bear, a direct subsidy for the project capital expenditure of an estimated 5.6 billion US dollar, or roughly 1 per 3 of Timor-Leste Petroleum Fund would be required. Thus, the option for the pipeline to Timor-Leste appears to be a remote one. Regulatory structure. With the implementation of the new spatial regime, the current applicable twofold regulatory framework will be harmonized and replaced by a single spatial regime framework, namely the existing titles, will be converted into one single PSC, the Greater Sunrise Production Sharing Contract. The treaty establishes a two-tiered regulatory structure for the regulation and administration of the Greater Sunrise Spatial Regime, consisting of a designated authority responsible for carrying out the day-to-day regulation and management of petroleum activities in the spatial regime area. Pursuant to Article 6 of the treaty, the designated authority is the Timor-Leste National Authority for Petroleum and Mineral Resources, or ANPM. This authority acts on behalf of Timor-Leste and Australia and reports to the Governance Board. The Governance Board is composed by 3 members, being 2 appointed by Timor-Leste and 1 by Australia. Other fields. The other petroleum field within the GPDA or in the Australian Exclusive Zone, Bayu Undan, Kitan and Kitan Relinquished Areas and the Buffalo are subject to transitional provision laid down in Annex D to the treaty. This transition regime establishes that the petroleum activities entered into under the term of the now revoked Timor Sea Treaty and the International Unionization Agreement shall continue under condition or term equivalent to those currently in force, with the necessary adjustment resulting from the fact that such field will now be deemed use being situated on the continental shelf of Timor-Leste, with the exception of the Buffalo oil field that will be subject to a new PSC to be negotiated and executed between Timor-Leste and the contractor. Entry into force and expected future development. Notwithstanding the fact that the treaty hasn't addressed all matters under discussion between the two countries, notably there's no final decision on the Timor South Coast pipeline and no comprehensive framework on local content was put in place, it is, nonetheless, a remarkable development and achievement for Timorese diplomacy and it ends a half-century dispute over the Timor-Australia maritime borders. Thank you.